On today's Q&A, we're going to go over a very common question people ask: how long will this conviction stay on my record? That's a very good question, and Louisiana has revamped its expungement laws within the last 5 years. And so what I'm going to do now is I'm going to talk about 3 different categories of people. First category is people that didn't get a conviction. Second is people that had a misdemeanor conviction. And third is people that had a felony conviction. If you are not convicted, and it's because the state of Louisiana has just not filed charges, you can move to expunge the arrest off of your record after the passing of the time limitations to bring charges. Now, if the district attorney dismisses the charges or has agreed not to prosecute and does what's called a no-bill letter telling the court that we have no intention of prosecuting this person, or they did prosecute and you were found not guilty. So again, the DA dismisses the case, formally says they're not prosecuting, or you are acquitted, you can move to have that arrest expunged off of your record immediately. So now the second category of people is what happens to folks who have been convicted of misdemeanors. Well, if you pled guilty to what's called 894, it's a procedural article that allows you to go on probation and get a misdemeanor set aside. The moment you complete probation, you can set aside the conviction and move for your expungement. Otherwise, you have to go for the passage of 5 years from when your sentence is complete without having a felony to then have to wait 5 years, and then you can move to have your misdemeanor set aside. Okay, now there are some exceptions to this rule. You cannot set aside and expunge a misdemeanor domestic violence conviction. You cannot set aside and expunge a domestic sex crimes conviction misdemeanor. You cannot move to set aside and expunge a DWI that went through diversion. You have to wait 5 years to do that one, okay? So that deals with the misdemeanors. The third category we are going to talk about here are felonies. Just like the misdemeanors have a probation set-aside provision, felonies do as well for nonviolent crimes, generally first offenders. You can have what's called an 893 plea. Again, it's a code article. Basically, it allows the court to not impose a sentence, put someone on probation, they do what they have to do. They can move to set aside the conviction and go and expunge it off their record. Now, you should know that this conviction is still on your formal record for law enforcement and court purposes, for purposes of possessing a gun, things of that nature, but it's shielded from the public, shielded from schools, shielded from employers in most instances, and so you can check the box that says you're not a convicted felon. So if you have pled guilty under Article 893, you have that opportunity available. Also, if you didn't, but 10 years has gone by and you've not been in any trouble, no new arrest, you're then able to move to set aside the felony conviction. Now, there are some exceptions to this. Certain crimes of violence, you cannot do the 10-year set aside. Certain sex crimes, you cannot do the 10-year set aside. And then drug distribution or serious possession crimes, you cannot do the 10-year set aside. So what's a serious drug possession? Those are generally your weight cases. You've had so much poundage that you've moved from a simple possession to a greater level felony. So those are the exceptions to the 10-year felony set aside rule.